So today we will talk about the calculation, how we are going to calculate the amount of compensation, what is to be paid to an employee in case of any accident. Or it can be an injury cost or sometimes death would have occurred for the employee. So we will talk about the calculations in under the Employee Compensation Act 1923. So already as we are aware that this is one of the Social Security Act which tries to protect the employee in case of any mishappening. Now, when we talk about this calculations are concerned, we have to know about the occupational diseases. So, what are the occupational diseases which an employee will be encountered because due to his employment? So, we have three schedules. So, one is Part A under Schedule 3, Part B under Schedule 3, and Part C under Schedule 3. So, Part A deals with any disease which has been contracted by the uh, employee which is peculiar to that particular employment. So that can be with respect to example, it can be a parasitic disease or any such diseases which is caused by compressed air. So any compressed air or sometimes due to lead or toxic components or because of any nitrous fumes. So poisoning of nitrous fumes which is present in the particular factory or orgophosphorus components. So in such case, the employer is liable to pay compensation when an employee employed by him contacts with such diseases. And the second case, we talk about Part B diseases. So it is a disease which is caused to them for a continuous period of not less than 6 months. So this period shall not include a period of service under any other employee. So this is only the particular employment where he is working at the present situation. Regarding this employment, so the diseases which are covered under Part B or related to phosphorus or mercury utility or benzene or radioactive substances or nitro or aminotoxic derivatives using of benz or homogeneous, and it also includes carbo disulfide or nitroglycerin or some other nitro acids. Even it can be disease caused due to alcohols and ketones. And so if an employee is having cataract and it is especially due to his occupational usage or the work is it is a work related disease due to the high exposure of infrared radiations. So he has developed a cataract or sometimes skin diseases. So the skin diseases can be due to physical usage or chemical or biological agents. Then regarding noise, so when he's working and because of the high volume of noise which has been in the particular premises, he may have some hearing impaired or he may develop asthma or bronchitis or sensitizing agents due to his work process. Sometimes even serious diseases like lung cancer, and that is caused by the asbestos utility. This is more prolonged with the manufacturing of asbestos sheets. Then regarding snow-bound areas, they may have snow blindness, and in case they are working in an extreme cold or extreme hot climate also, they may have some disease. Then Part C schedule will has to be read with the continuous period as specified by central government. So the period of disease is to be continuous and it is read by the central government specification. So in this case, if he is in the one or more service, more employee service, or he has to prove himself the contrary things. Then what are the list of occupational disease which is falling under Part C is any disease which is caused because of pneumococcus or silicosis or biogases or bronchopulmonary diseases which is caused due to cotton or flax, hemp or sisal dust, or sometimes allergic ultivis caused by inhalation of organic dust, or bronchopulmonary disease which is caused due to hard metal. So this is with respect to the list of diseases which are falling under occupational disease, Schedule A, Schedule B, and Schedule 3. Now, how we are going to calculate the compensation? This is a very important thing which we have to take into consideration when we talk about the calculation of compensation is the age of the employee. So the age is a very important factor, and we have a relevant factor which specify based on his completed age factor. We have to find out the relevant factor. So here we have a slide on the relevant factor also. So his age is 16, the relevant factor is given. So based on this age, completed age, we will calculate the relevant factor. So even that relevant factor is given for your understanding at the end of this PPT. Now, as I told you, higher the age, the lower will be the compensation, because when his age is very high, he will have a little bit of service. When his age is very young, he will have more service. So based on that only, we are going to calculate, and based on that only, relevant factor has been designed. So here, there is a death of an employee, and his age is 3000, and his age is 23 years. So here, the relevant factor, as I told you, which is given in schedule, is based on his age factor. We have to take that into consideration, and it is given as 219.95, and the compensation we will calculate based on the formula which we have for calculation of the compensation. So when you talk about compensation, this compensation is payable to employee based on the nature of his injury, which is caused by accident, and we have to take into consideration the monthly wages, what the monthly wages is getting, the employee is getting, and the relevant factor. So this relevant factor is a very important component. We have to calculate the equivalent amount of compensation which has to be given in the form of lump sum. And there is no distinction between adult and minor in the case of compensation. And this compensation is payable for death, permanent total disablement, permanent partial disablement, and temporary disablement. So this temporary disablement, we have to find out whether it is total or partial. So we have to talk about the schedule 4, which is much relevant for the relevant factor analysis for the compensation. So here we have a formula how to calculate it. So based on the relevant factor, we take the amount of compensation what is to be paid to the employee. So here we have schedule 2 refers to the list of persons who are engaged in different employment, and schedule 3, as we discussed, we have part A, part B, and part C, and schedule 4 we have already seen the relevant factor. So based on this only, we will take the calculations how we are going to calculate the amount of compensation for the employees to be given. Now, in case of the death of the employee, we have to take 50% as a compensation. So we have the compensation as a 50% of monthly wages what he is drawing into relevant factor by 8,000, whichever is more. So this is the compensation to be paid to an employee. Then in case of permanent total disablement, we will take it as 60% of the monthly wages. So in case of death, it is 50% of monthly wages. And in case of permanent total disablement, we will take that as 60% of the monthly wages into relevant factor. So as I already specified, this relevant factor is given in schedule 4 with respect to the completed years of his age. Then permanent disablement, we will take the amount of compensation as 60% of monthly wages into relevant factor. Then in case of a temporary disablement, we will take 25% of monthly wages, and we will not take the relevant factor into consideration. Now, cause of compensation, we will give the higher amount of this 1 and 2. So whichever is higher, we will take that into consideration. So in case of death, it is 1,40,000 or 60% of monthly wage into relevant factor. In case of permanent total disability, it is 1,20,000 or 50% of monthly wage into relevant factor. Then in case of permanent partial disability, it is estimated based on the pro rata basis. And in case of partial disablement, we will take, if it is lasting for more than 3 days, then we will take 25% of the monthly wages. So here we are taking monthly wages to be limited to 8,000 as a sample study for this particular purpose. Then regarding the part 3 schedule, as I told you, so if your employee, when is claiming the compensation under part 3 of occupational disease schedule 3, then he has to prove that employer shall be liable only for the payment of compensation in such proportion as the commissioner he thinks. So in case particular situation, he will tell us how much is to be given as a compensation. Only based on that he will be given compensation. Then regarding this diseases, I have taken some of the pictures so for your understanding. So what are the type of disablement a person can incur? See here, head injury, here he is falling down, here some issue with respect to his fingers, here fractures, here he has amputated his fingers. So here he has a fracture, and here also he is having disablement. So based on this disablement, we will try to calculate the compensation. So here, in case he is having more other remedies in favor of employer, so we have to give section 10, under section 10, a notice and a claim. So for no claim for compensation shall be entertained by the commissioner unless they give a notice of the accident. So if an accident has encountered in a particular premises, a notice has to be intimated that there is an accident has occurred, and there is a manner how they have to prescribe. So it is given by the relevant government, and within a practical time happening, that is they have to give an intimation. So they have taken 2 years of the occurrence of the accident, but still there are some provisions which are favoring the workman. Regarding section 11, subsection 2, medical examination. So suppose a workman is submitting a medical examination. So that has to be done by a qualified medical practitioner if it is required by the employer or the commissioner. And if he is not having any right to claim compensation, and that should be suspended during the continuance of such period if he does not give sufficient cause for refusal. Then regarding appeal, so whether the appeal can be done. So under section 30, subsection 1, an appeal should lie to the High Court. So within 60 days. So there is a substantial question of law which is involved. Within 60 days, he can go for an appeal. Then regarding section 4 of the Act, so the amount of compensation which is payable as under. So where death has resulted as an injury. So when death has occurred, an amount equal to 50% of the monthly wages of the deceased workman multiplied by relevant factor given in Schedule 4. So we have to take a here. So here they have given us the thing. And the amount they have given also. So into 50% of this, that is 1,250. So relevant factor is 197.06. So the total compensation is up to 2,46,000. This is total compensation. But and here the workman is having wages of more than 4,000. So here we are taking only 4,000 for the calculation of other compensation in case of death or permanent disablement. Then in case of disablement, total disablement, then the injury is amounting to total disablement. Then we will take 60% of the monthly wages of the injured workman as already given, or 1,40,000, whichever is more. So here they have given a person who is having age of 35 years and he is meeting with an accident and he suffers a permanent total disablement, and particularly the occurrence is in the course of employment. So we know it is arising out of employment and in the course of employment, that should be the cause for compensation. And at the times he draw the salary is 2,500. So his compensation will be based on the 60% of this 1,500 into relevant factor. So this relevant factor is common as we have taken this sample as 35 years. So here we calculate the total amount of compensation. When in case of where permanent disablement is there due to the injury, In that case, the case of injury specified in part 2 of Schedule 1, such percentage of the compensation which would be have been payable in the case of permanent total disablement. So here we take that based on the loss of his earning capacity. So we already know that disablement is he's losing his earning capacity or he cannot put in the full effort which he was doing in the particular job. So because of his disability, he is losing his earning capacity. So this injury would specifically cause a loss to the earning capacity of the employee. In such case, only he can claim compensation. In the case of injury which is not specified in Schedule 1, then we will take the percentage of compensation in the case of permanent total disablement as a proportionate to the loss of his earning capacity. So this loss of earning capacity, who will tell us? Only by the medical practitioner. So he will be assessed by a qualified medical practitioner, and they will tell us the percentage of loss of his learning capacity. In case of temporary disablement, and it can be total or partial, that is due to the injury, only half the monthly payment of the sum, whatever is the amount to be given, only half the month of the sum wages which is being paid, or that is to 25% of the monthly wages of the employee, that should be paid to the employee in case of whether it is a temporary disablement, whether it can be a total or a partial thing. Then we have to have in our mind the age, as I told you, is a very important factor, and we will take based on the Schedule 4 relevant factor, we have to take the age and the relevant factor. So we will take that, and based on the years of completed of last birth. So based on his completed age, whatever age he has completed in the last birthday, that should be taken into of the workman immediately preceding the date when the compensation fell down. So this is how we have to work out. And when we talk about the monthly wages of the workman which is exceeding 4,000 rupees, then his wages for the purpose of calculation of compensation shall be 4,000 rupees only. So in case of calculating the monthly wages, we have to take about bonus, accommodation, ration, clothing, medical reimbursement, and washing allowance, whichever he is eligible and he is drawing at the time of this injury. So this is based on the standard schedule of rates which is given from time to time. And I have already mentioned you about this relevant factor. So based on the relevant factor, this is the factor is age. First column is his age and second one is relevant factor, and this is Schedule 4. So based on the Schedule 4 only, these compensations are being paid. And regarding the monthly wages, so this monthly wages are to be paid based on the month's service. So sometimes it is given as a wages, or it is also called as a piece rated or whatever it is. And how that is being calculated is during that particular injury. So he has to put in a continuous service of not more less than 12 months immediately preceding the accident. So when employee meets with an accident, so we will take only the relevant immediately preceding the accident, how many months he has worked. So it should not be less than 12 months, and he has been in service, and only then he is liable to get the compensation. And we will take the monthly wages of the workman and only 1/12 of the total wages which have fallen due to payment in case based on the last 12 months of his wages. Suppose he has a whole of the continuous period of service immediately preceding the accident, during that which the workman was in the service of an employer who is liable to pay the compensation was less than 1 month. Then we will take the monthly wages of the workman based on his average monthly amount, which during the relevant 12 months immediately preceding the accident, which he has earned by the workman on the same work by the same employer, or if there was no workman so employed, then workman employed a similar work in the same locality will be taken into consideration if you are not able to calculate the wages. So we will take into consideration the persons with whom they are working in the same industry, then we will take that wages into a real factor, or similar work in the same locality. In other cases, including the cases where it is not possible by font of necessary information to calculate the monthly wages, so as mentioned above, in this case, the monthly wages will be 30 times the total wages earned in respect of the last continuous period of service, immediately preceding the accident, from the employer who is liable to pay compensation divided by the number of days comprising such period. And dependency on employee, this is very important, who are called as dependents. So section 2D, in case if it is a death of an employee, only the dependent person, legal dependents or legal heir can claim the compensation. So section 2D of this particular act, Employee Compensation Act, deals with dependent, meaning any of the relatives of the deceased workman, namely it can be a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother, if wholly dependent on the earning of the workman. So if they are wholly dependent on the earning of the workman at the time of his death, a son or a daughter and who has attained the age of 18 years and who is infirm, or in case if wholly or in part dependent on the earnings, so they can fully depend or only partly dependent on the deceased workman at the time of his death, or a widower, a parent other than a widowed mother, or a minor legitimate son, or an unmarried illegitimate daughter, or a daughter legitimate or illegitimate. So both are par they considered, or adopted if married and a minor, or if widowed and minor, or a minor brother, or a unmarried sister, or a widowed sister if in case of a minor, a widowed daughter-in-law, a minor child of a predeceased son, a minor child of a predeceased daughter, in where the parent, none of the parent of the child is alive, or a paternal grandparent if no parent of the workman is alive. So they are called as dependent. Then, as I told you, the commissioner, he is having the power. So he is a commissioner is nothing but under section 20 means a person, that is a commissioner who is called as a commissioner under the relevant section. So under Employees Compensation Act 1923, section 20 deals with the commissioner. So here we are talking about the reference section 19.1. So if any question is arising in any proceeding under this act, so in case of the calculation of the liability, what is the amount of liability to be paid as compensation, and any questions has been raised with respect to insured or it is not in case of a workman, the total amount of duration of compensation. So that is question, and it is in fault, it can agreement, that is can be settled only by a commissioner. Then section 19, subsection 2, no civil court shall have jurisdiction to settle or decide or deal with any question which is by or under this act required to be settled. So when the commissioner is having the power, no civil court can settle such inquiry or question in case of calculation of the liability incurred under this particular relevant section. Then how this particular commission is appointed? So section 20, subsection 1, the state government by notification, the official gazette, appoint any person. So any person, one who is qualified and deemed fit, is being appointed through the official gazette as a commissioner. Then section 20, subsection 1A deals with the no application for the settlement of any matter by the commissioner. That is, other than an application by the dependent or the other dependent for compensation, no one can file a application then shall be made unless and until some question has arisen between the parties. So who are in connection with it, they have to be unable to settle by the agreement. Then regarding section 20, subsection 2, an application to a commissioner can be made in a form. So the form will be specified and that should be accompanied by the relevant fees, if any, and it should be in a prescribed form and it should contain all the additional informations and particulars which are necessary and what are the particulars are given. They have to give a concise statement. So of the particular relief what has been made, claimed. So in applications, they have to give a concise statement and what is the amount of relief or order for the claim they have made by the applicant. Suppose in case of a claim for compensation against an employer, then the date of service of notice of the accident. So when the particular incident has been taken a note of it, that has to be specified. And if suppose such notice has not been served, then if it is not being served in due time, then that particular reason why there is an omission of it has to be analyzed. Then the names and address of the parties. So in case of application made by the dependents for compensation, a concise statement of matter on which agreement has and of this or which agreement has not come to, and section 23(3) reads with that if the applicant is sometimes illiterate or for any other reason he is not able to give the details, that is the required information in the form of writing, then the application shall, if the applicant so desires, can be prepared under the direction of the commissioner. So this is with respect to the particular relevant sections of workman compensation with respect to disability.